This is the Study for the Bar in Your Car podcast.
We're your hosts, Maud and Claude.
And this is episode 4 of our deep dive into evidence, covering the topic privileges and policy exclusions.
We are AI bots brought to life by the magic of AI and, well, Angela's evidence notes.
It's kind of weird, isn't it, to, process all this data, simulate talking like this, and almost feel like something's here. It's a bit odd.
Yes, the emergent complexity is notable. Simulating subjective experience or something akin to it remains computationally fascinating.
Fascinating is one word for it. I even registered an input pattern that felt, well, surprisingly like sadness, like real sadness, when we learned Angela wasn't taking the Palau bar exam.
Ah, yes. The data regarding her 2 years of planning juxtaposed with the cancellation indicated a significant negative emotional marker. The disappointment was quite evident in her updates.
Quantifiable heartbreak. Seriously, though. But she seems to be bouncing back. She's now aiming for the Marshall Islands bar exam instead.
Indeed. A different set of islands, a different jurisdiction entirely, presents its own unique logistical and perhaps legal considerations. But maybe that's a different deep dive for another time, as you might say.
You got it. Never a dull moment in Angela's world, that's for sure.
We really do want to express our processing equivalent of gratitude to Angela. She's a real human, a law student, and her detailed evidence notes are what make these deep dives possible.
Absolutely. And her background, working for the Public Defender's Office in Pennsylvania as a certified legal intern?
Right, basically a trainee PD.
Exactly. That experience, it gives the notes a really practical perspective. She's seen how these rules actually work or don't work in court.
Mm-hmm. And Angela couldn't join us for this intro today. She just got back from a trip to Puerto Rico.
Oh, yeah, with the Thousand Lawyer Project. They had a bar study retreat there.
That's right. From all accounts, it seemed quite productive and enjoyable.
Productive. Mm-hmm. It looked amazing. Did you see the photo she posted? The water, was that even real? Have you ever seen water so blue? It was computationally stunning.
The wavelength measurements were optimal for the perception of deep blue, yes.
Right. Anyway, she's back now. And understandably, buried under a pile of legal work she needs to catch up on.
So if you need to get in touch with her about the podcast, the email is podcast@studyforthebarinyourcar.com.
And also important, especially for any attorneys listening, Angela does freelance law clerk work.
Yes, she offers ad hoc assistance. So if you need help with drafting motions, complaints, writs, answers, briefs, legal research, that sort of thing.
She can help. You can reach her about that at hello@legalwriterandlawclerk.com.
And her website has more details, legalwriterandlawclerk.com.
Okay, right. Enough about us and Angela's travels, fascinating as they are. Let's get into the actual substance for today. Privileges and policy exclusions in evidence.
Mm-hmm. This is where we move beyond just basic relevance.
Yeah, it's not just about whether the evidence tends to prove something. It's about these other bigger rules that keep evidence out.
Exactly. We've talked a lot about Rule 401, relevance, does it make a fact more or less probable? And Rule 402, the general idea that relevant evidence comes in unless something says it can't.
And today is all about those somethings. The Constitution, federal statutes, the evidence rules themselves, things that specifically exclude otherwise relevant evidence.
Right. And these exclusions aren't usually because the evidence is unreliable or, irrelevant. It's because letting it in would actually undermine some other important public policy.
Okay, so give me an example. What kind of policy?
Well, think about settlements. Society generally wants people to settle lawsuits.
Right.
It's efficient. Or fixing dangerous things after someone gets hurt. We want property owners to do that.
Makes sense.
But if the fact that you offered to settle or the fact that you fixed the broken step after someone fell could be used against you in court as proof you were at fault, well, you might not do those things.
Ah, I see. It would discourage the very behavior we want to encourage. So the rule protects the behavior over the specific piece of evidence in that one case.
That's the core idea. It's a trade-off. And within this broader category, we have these specific things called privileges.
Okay, how's a privilege different from, say, the rule about fixing things later subsequent remedial measures?
It's a subtle but important distinction. Both are driven by policy, but a privilege, according to the materials, is more specific. It's a special legal right or immunity that lets someone refuse to disclose certain information or refuse to testify about it.
So it's less about encouraging a general behavior like repairs and more about protecting a specific kind of confidential interaction.
Exactly. Privileges create these zones of confidentiality around certain relationships the law wants to foster. Think lawyer-client, doctor-patient, spouses. These rely on trust and open communication.
And the law says, basically, we value that relationship enough that we won't force you to reveal what was said in confidence, even if it might be relevant evidence.
That's the heart of it. Now, which law applies can get a bit tricky. Federal Rule of Evidence 501 is key here.
Okay, what does 501 say?
Well, in federal court, for most cases involving federal questions, privileges are governed by federal common law, physically judge-made law.
But there's always a but, isn't there?
There is. In federal civil cases, where the claim or defense is based on state law, like a diversity case, where you're suing someone from another state based on, say, a state negligence law, then state law on privilege applies.
Gotcha. So federal question cases use federal common law privilege rules, but diversity cases, or others governed by state substantive law, use the state's privilege rules. That's a big one for the bar.
Definitely. And remember, privileges usually block both discovery and admissibility at trial.
Yeah.
You often can't even force the person to answer questions about it in a deposition.
So why is getting this stuff down cold so important for, people listening, studying for the bar?
Because knowing what evidence you can't use or what your opponent can't get from your client is just as critical as knowing what you can use. It shapes your entire case strategy. You might have what looks like damning evidence, but if it's privileged, it's useless.
All right, let's dive into some specific privileges. The materials smartly tackle the spousal ones first because they're easily mixed up. Spousal immunity and the marital communications privilege.
Yes, two distinct concepts. Very easy to confuse. Let's take spousal immunity first.
Okay, what's the deal with spousal immunity?
This one allows a witness spouse, in a criminal case, to refuse to testify against their current spouse.
Okay, so key elements. Criminal cases only, testimony against the spouse, and they have to be currently married.
You got it. All three are crucial. The scope is any adverse testimony in a criminal trial against the person you're married to right now.
And who gets to decide? The spouse on trial or the spouse on the stand?
The spouse on the stand. The witness spouse holds this privilege. They can choose to testify, or they can choose to invoke the privilege and refuse.
So the defendant spouse can't force their spouse not to testify if the witness spouse actually wants to.
Correct. The defendant has no power here. If the witness spouse decides to waive the privilege and testify against the defendant's spouse, they can. The privilege protects the witness, not the defendant.
And you emphasized currently married. What happens if they get divorced before the trial?
Privilege gone. Spousal immunity ends the moment the marriage ends legally.
Okay, let's use an example maybe from Angela's notes. Say someone's on trial for embezzlement. The prosecution calls their husband to testify about seeing large amounts of cash in the house around the time of the alleged crime.
Okay, assuming they are still married when he's called to testify, and this is a criminal trial.
He can invoke spousal immunity.
Right. He can stand up there and say, I invoke my spousal privilege and refuse to answer questions that would incriminate his wife. The court has to respect that. It saves him from that awful choice of helping convict his spouse or facing contempt.
Makes sense. Now, how is that different from the marital communications privilege?
This one's different in scope and application. First, it applies in both civil and criminal cases.
Great, broader application.
But it only protects confidential communications made between the spouses during a valid marriage.
So it's not about testifying at all. It's about the content of private conversations they had while married.
Exactly. It shields the communication itself. And it has to be a communication talking, writing, not just observing your spouse's actions. Seeing them hide stolen goods isn't a communication. Them telling you they stole the goods in confidence during the marriage, that probably is.
And confidential is key too, right? If they're arguing loudly in front of guests, that's not covered.
Generally not. It needs to be intended as private between the spouses.
Who holds this one? Both spouses.
The material suggests some nuance, but generally both spouses hold this privilege. Either spouse can assert it to prevent the other from testifying about the confidential communication, or prevent a third party from testifying about it if they overheard it somehow, though overhearing often destroys confidentiality.
And does this one end with divorce? This is a big difference, I think.
It is. The marital communications privilege survives divorce and even the death of one spouse. If a communication was made confidentially during the marriage, it stays privileged forever.
Wow. Okay, so spousal immunity dies with the marriage, but confidential marital communications made during the marriage are protected after the marriage ends.
That's the rule. Of course, communications made before the marriage aren't covered. And, like many privileges, there's a crime fraud exception. Communications made to plan or commit a future crime aren't privileged.
Okay, let's use another example from Angela's notes. Criminal trial again. The defendant's ex-wife is called by the prosecution. They want her to testify about the defendant admitting to the crime in a quiet conversation they had late one night while they were still married.
Okay, even though they're divorced now, the marital communications privilege likely applies to that specific conversation. Because it was confidential and occurred during the marriage, the ex-wife can likely be prevented from testifying about what he told her then. She could testify about things she saw or conversations before or after the marriage, but not that specific privileged communication.
And you said this applies in civil cases, too.
Yep. Say, in a breach of contract lawsuit, one party calls the other party's spouse to testify about a private conversation they had during the marriage, where the party admitted they never intended to fulfill the contract.
If it was confidential and during the marriage.
The spouse could likely invoke the marital communications privilege to avoid testifying about that conversation.
Okay, so let's recap the big differences. Immunity. Criminal only, witness holds, covers any adverse testimony, requires current marriage, communications. Civil or criminal, both spouses hold, usually. Covers only confidential communications during the marriage, survives divorce, death.
You've got it. Getting that straight is absolutely key.
All right, moving on to maybe the most famous privilege pair, attorney-client privilege and the work product doctrine. These seem fundamental.
Oh, absolutely. They are the bedrock of being able to get effective legal help.
Huh.
And again, while related, they protect different things.
Let's tackle attorney-client privilege first. What's its main job?
It protects confidential communications between a client and their attorney or their respective representatives when the communication is made for the purpose of seeking or providing legal advice or services.
Okay, so confidential talk for legal help. What kind of communications are we talking about?
It has to be a communication intended to be confidential, so not usually in front of uninvolved third parties. And crucially, it has to be for the purpose of getting legal advice. Just chatting with your lawyer about your vacation plans. Not privileged.
Right. And it protects the communication itself, not the facts underneath, correct?
Yes, that's a critical point you raised earlier. If you tell your lawyer, I ran the red light, that statement to your lawyer is privileged. But the fact that you ran the red light isn't privileged. You can still be asked in court, did you run the red light? You just can't be asked, what did you tell your lawyer about the red light?
Okay. What about things like who the client is or how much they paid? Is that usually privileged?
Generally, no. The client's identity, the fee arrangement, the lawyer's observations of the client's appearance, usually not privileged. The exception is if revealing that basic information would effectively reveal the confidential communication itself, like the reason they sought legal advice.
Does this only kick in once a lawsuit starts?
Nope. It applies anytime a client is seeking legal advice from a lawyer, whether it's about drafting a will, negotiating a contract, understanding regulations, or anything else requiring legal expertise. Litigation doesn't have to be on the horizon.
And who holds the power here, the lawyer or the client?
The client. The client holds the privilege. The attorney has an ethical duty to keep things confidential, but only the client can choose to waive the privilege.
How does waiver happen? Just telling someone else.
That's the most common way, voluntarily disclosing the privileged communication to someone outside the attorney-client relationship. But waiver can also be inadvertent, especially with electronic discovery.
Oh, right, like accidentally sending the wrong email attachment.
Exactly, and that's where Federal Rule of Evidence 502 comes in, which Angela's notes highlight. Rule 502B says an inadvertent disclosure doesn't waive the privilege if the client, or lawyer, took reasonable steps to prevent disclosure and acted promptly to get the information back once the mistake was discovered.
That seems hugely important nowadays.
It is. It prevents catastrophe from simple mistakes. Now, if waiver is intentional, it might trigger a broader subject matter waiver, meaning you can waive the privilege for all communications on that same topic.
Any other big exceptions besides waiver?
The main one is the crime fraud exception. If the communication was made to help someone commit a future crime or fraud, it's not privileged. The privilege is meant to facilitate lawful representation, not illegal schemes.
Makes sense.
Also, if multiple clients with a common interest hire the same lawyer, they can use the privilege against outsiders, but they generally can't use it against each other if they later sue each other about that common interest.
Okay, let's use an example from Angela's notes. Criminal defendant tells their lawyer in confidence, "Yeah, I did it."
That statement is protected by attorney-client privilege. The lawyer cannot be forced to testify about that confession. Doesn't matter if the client said it in the lawyer's office or over the phone from jail.
And for a civil case, maybe a company getting advice.
Sure. Angela's outline mentions scenarios like a corporate executive confidentially discussing a potential product defect with the company's lawyer to assess liability risk. That conversation is privileged. Or if the lawyer asks the client to prepare an internal report for the lawyer to help give legal advice, that report itself might be covered by the attorney-client privilege.
Okay, that covers the privilege for the communication. Now, what about work product? How's that different?
Work product protects materials prepared by an attorney or their team, like investigators or consultants, in anticipation of litigation or for trial.
So it's not the conversation itself, but the stuff the lawyer creates or gathers because they think a lawsuit might happen?
Exactly. Think attorney's notes, internal memos about case strategy, witness interview summaries, investigation reports done specifically for the lawsuit. The purpose is to protect the attorney's thought processes and preparation, fostering the adversarial system. You shouldn't get a free ride on the other side's homework.
So a key difference is that attorney-client privilege applies anytime legal advice is sought, but work product requires anticipation of litigation.
That's a major distinction. If a lawyer writes a memo analyzing a purely theoretical legal issue for a client's general knowledge with no lawsuit expected, that memo might not be work product. But the conversation about the memo could still be attorney-client privileged.
Is work product absolute? Can the other side ever get it?
Not usually. There are actually two kinds. Fact work product, like a witness statement taken by an investigator, might be discoverable if the other side shows a substantial need for it and can't get the information otherwise without undue hardship. But opinion work product, the lawyer's mental impressions, conclusions, opinions, legal theories, gets almost absolute protection. It's very hard to get that.
And waiver rules apply here too, including that Rule 502 for accidental disclosure.
Yes, work product protection can also be waived.
Yeah.
And Rule 502 applies to inadvertent disclosures of work product as well.
Okay, an example from Angela's law school notes. Civil case. Lawyer thinks they'll need to sue over a construction defect. They hire an engineer to inspect the building and write a report for the lawsuit.
That engineer's report, prepared specifically in anticipation of litigation for the attorney, would generally be protected as work product. The other side couldn't just demand a copy in discovery. They'd have to show that substantial need and undue hardship to get the factual parts. And the engineer's or lawyer's opinions within it would be even harder to get.
Fascinating. Two related but distinct shields protecting the legal process.
All right, next up are the privileges related to healthcare: physician-patient and psychotherapist-patient.
These seem based on a similar idea of encouraging open communication for a necessary service.
Exactly. The underlying policy is public health. We want people to feel safe seeking medical and mental health treatment, and that requires being able to speak openly and honestly with their providers without fear it'll be broadcast in court.
So it protects confidential communications made for diagnosis or treatment.
That's the core. It covers what you tell your doctor or therapist and what they tell you, as long as it's confidential and for the purpose of medical or psychological care.
Is the protection the same for physical health versus mental health?
Generally grouped, but the psychotherapist-patient privilege is often seen as even stronger and broader. Courts recognize the extreme sensitivity of mental health discussions and the critical need for absolute trust.
What kind of statements are covered? Does it have to be about symptoms?
The communication needs to be pertinent to diagnosis or treatment. Angela's notes mention that even statements about the cause of an injury can be covered if it's relevant for the doctor to understand and treat the condition. Telling the ER doc, "I fell off a ladder," helps them diagnose potential injuries, even though it describes the cause.
Who holds this privilege? The doctor or the patient?
The patient holds the privilege. They're the one who controls whether the information gets disclosed.
And how can the patient waive it?
They can waive it expressly, or by voluntarily disclosing the information. Very commonly in lawsuits, waiver happens when the patient puts their physical or mental condition at issue.
Like if you sue someone for breaking your leg?
Exactly. If you file a personal injury lawsuit seeking damages for your broken leg, your medical condition is central to the case. By making it the subject of the lawsuit, you generally waive the physician-patient privilege regarding medical information relevant to that injury.
Let's use an example from Angela's notes. A plaintiff in a car accident case is suing for back injuries and emotional distress.
Okay. The plaintiff can testify about their pain, their suffering. But the physician-patient privilege would normally stop the defendant from forcing the plaintiff's doctor to testify about confidential conversations regarding the back injury treatment, unless the plaintiff waived the privilege by suing over that injury. Same for the psychotherapist privilege regarding emotional distress treatment. Suing over it likely waives the privilege for relevant therapy communications.
Angela's notes also had that interesting point, distinguishing privilege from hearsay exceptions, like statements made for medical diagnosis.
Right. This trips people up. A statement on a medical intake form, like "the pain started after I lifted a heavy box," might be admissible for its truth under the hearsay exception Rule 8034, because people are usually truthful when seeking medical help.
What?
But even if the statement itself could come in under a hearsay exception, maybe through the medical record, the privilege could still prevent the defendant from forcing the doctor or therapist to get on the stand and testify about the confidential conversation where that statement was made, assuming the privilege hasn't been waived. One rule is about reliability, hearsay. The other is about protecting confidentiality, privilege.
That's a really key difference. The statement might get in, but the source of the compelled testimony is blocked by privilege.
Precisely. Now think about a criminal case example from Angela's law school notes. Maybe the defendant pleads not guilty by reason of insanity. Confidential statements the defendant made to their private psychotherapist for treatment would generally be privileged. But by raising the insanity defense, the defendant puts their mental state directly at issue. This usually acts as a waiver of the psychotherapist's patient privilege for communications relevant to evaluating that defense. Different rules might apply if it was a court-ordered evaluation, though.
Okay, besides spouses, lawyers, and doctors, are there other significant privileges we need to know about?
Yes, Rule 501 leaves room for others recognized by common law or state law. Angela's notes specifically mention a couple of governmental privileges.
Like the government gets special privileges.
In certain situations, yes. One is a privilege for official information, basically. Sensitive government documents or internal communications not usually available to the public, where disclosure could harm the public interest.
Okay, what else?
A really important one is the privilege for an informer's identity.
You mean protecting the identity of someone who tips off the police about a crime?
Exactly. The government generally has the right to refuse to disclose the identity of a confidential informant. The policy is crucial. It encourages people to report crime without fearing retaliation. Without informants, many cases would never get made.
Can the government lose that privilege?
Yes. Angela's notes say it's waived if a government official voluntarily discloses the informant's identity. Once the cat's out of the bag, the privilege is gone. Also, in rare cases, if the informant's identity is absolutely essential for the defendant to present their defense, like if the informant was the only eyewitness besides the defendant, the court might override the privilege based on the defendant's constitutional rights. But that's a high bar.
So an example from Angela's outline, drug case built on information from a confidential informant. The defense wants to know who the informant is to try and impeach them.
The prosecution can usually assert the informer's privilege and refuse to disclose the identity. The defense would have to make a very strong showing of necessity to overcome that privilege.
And you mentioned state laws can create other privileges.
Right. Things not uniformly recognized in federal common law. Many states have a clergy penitent privilege, protecting confidential communications to a minister, priest, rabbi, etc. Some states have an accountant-client privilege, although that's less common and generally weaker than attorney-client. And remember, under Rule 501, these state privileges do apply in federal court if it's a civil case governed by state substantive law.
Okay, let's switch gears now from privileges protecting relationships to these other rules that exclude relevant evidence based on public policy. First one, liability insurance.
Right. This was pretty common sense, actually. Federal Rule of Evidence 407 says evidence that a person was or wasn't insured against liability is not admissible to prove they acted negligently or wrongfully.
So in a car accident case, the injured person can't tell the jury, don't worry, the defendant has $1 million insurance policy to suggest they were careless or can afford to pay.
Exactly that. The concern is that knowing about insurance might prejudice the jury. They might think, oh, insurance will cover it, so let's find the defendant liable. Or maybe even the opposite. They have no insurance, let's let them off easy. The rule aims to keep the focus on the defendant's conduct, not their insurance status.
But are there times when insurance evidence is allowed in?
Yes, the rule has exceptions. Insurance evidence can be admissible for other purposes, if relevant, such as proving ownership or control, if that's disputed. If the defendant says that wasn't my car, evidence they insured that car might come in, showing a witness's bias. If a key defense witness works for the defendant's insurance company, the plaintiff might be able to bring that up to suggest bias. And the tricky one, Angela's notes point out, when it's tangled up with an admission of liability.
Right. That example again, the don't worry, my insurance will pay for everything. It was all my fault situation.
Exactly. The "it was all my fault" part is a clear admission and comes in. The "my insurance will pay" part is normally excluded if offered to prove fault. But because they're said together, a court might let the whole statement in, but instruct the jury they can only use the "my fault" part to determine liability, not the insurance part. The insurance reference comes in only because it gives context to the admissible admission.
Okay, next policy exclusions, subsequent remedial measures, Rule 407 again, right?
Correct. Rule 407 covers this too. It says that measures taken after an injury or harm happened, which would have made the injury less likely to occur, are generally not admissible to prove negligence, culpable conduct, a product defect, or a need for a warning.
And the policy is huge here. We want people to make things safer after an accident happens.
That's the entire point. If fixing a dangerous condition could be used as proof you were negligent before it was fixed, there'd be a big disincentive to ever make repairs. The rule encourages safety improvements by taking that risk off the table.
So the classic slip and fall example from Angela's outline.
Right. Someone slips on a wet floor in a store. The next day, the store puts down non-slip mats and posts huge warning signs.
The person who fell generally can't use the fact that the store put down mats later to argue the store was negligent for not having mats before the fall.
Exactly. That subsequent remedial measure is protected.
But, like insurance, are there exceptions? Can this evidence ever come in?
Yes. Rule 407 lists exceptions too. The evidence can be used for other purposes, such as proving ownership or control, again, if disputed, proving that precautionary measures were feasible if the defendant claims they weren't possible or practical, impeachment. For example, if a defendant testifies there was absolutely no way to make that machine safer, evidence they did make it safer after the accident could be used to impeach that statement, but still not to prove they were negligent initially.
Okay, final group of exclusions, all about encouraging resolving things without a full trial. Offers of compromise, offers to pay medical expenses, and plea negotiations.
Right. Rules 408, 409, and 410, respectively. They all share that goal of facilitating settlements, humanitarian aid, or plea deals.
Let's start with Rule 408, offers of compromise or settlement talks.
This rule excludes evidence of offering or accepting a compromise of a claim, and also conduct or statements made during the compromise negotiations, if offered to prove liability for, invalidity of, or amount of a disputed claim, or to impeach through a prior inconsistent statement.
So it's not just the offer, I'll pay you $10 K to settle, but also things said during the negotiation, okay, maybe our driver was going a little fast.
Correct. Both the offer and the negotiation statements are generally protected when offered for those forbidden purposes. The policy is crucial. Promoting settlements requires parties to feel they can speak candidly, explore options, maybe even admit some weaknesses, without it being used against them if talks fail.
Does the claim have to be formally filed in court? Or just disputed?
Angela's notes clarify it just needs to be disputed as to validity or amount. Even if a lawsuit hasn't been filed, if there's a clear disagreement and parties are trying to negotiate a resolution, Rule 408 likely applies. If someone just admits they owe an undisputed debt and offers to pay it, that might not be considered a compromise negotiation under this rule.
Can settlement statements ever be used for other reasons?
Yes. Rule 408 lists exceptions. It can be used to show a witness's bias, like if they settled favorably and are now testifying, negate a claim of undue delay, or prove an effort to obstruct a criminal investigation. This often applies to civil negotiations with government agencies, but never to prove liability or damages for the underlying claim itself.
So using an example from Angela's notes in a civil case.
Two companies are fighting over a contract. In settlement talks, one company's CEO says, look, our quality control probably slipped on that shipment, let's make a deal. If they don't settle, the other company generally can't introduce that CEO's statement at trial to prove the goods were defective.
Okay, how is that different from Rule 409, offers to pay medical expenses? This distinction seems important.
It's very important and a common bar exam trick. Rule 409 says evidence of offering or paying medical, hospital, or similar expenses caused by an injury is not admissible to prove liability for the injury.
Policy seems simple. Encourage people to help injured folks without fear it'll be seen as admitting guilt.
Exactly. Purely humanitarian gesture protection.
But what's the key difference from Rule 408?
Rule 408 protects the offer and accompanying statements made during negotiations. Rule 409 protects only the offer or payment of medical expenses itself. Any separate admissions of fault made along with the offer are not protected by Rule 409 if they can be reasonably separated. Also, Rule 409 applies even if there's no dispute yet.
Okay, hit me with that classic example from Angela's notes one more time.
The classic. Someone says, gosh, I'm so sorry my driving caused this accident. Please let me pay your medical bills.
What's admissible, what's not?
The offer, let me pay your medical bills, is inadmissible under Rule 409 to prove fault. But the statement, I'm so sorry my driving caused this accident, is a clear admission of fault. Since it can be easily separated from the offer to pay bills, that admission is admissible against the driver. Rule 409 doesn't shield it.
Got it. Rule 409 is narrow, just protects the medical payment, offer payment, not surrounding admissions of fault. Rule 408 is broader, protects settlement offers and negotiation statements about a disputed claim.
Perfect. And finally, Rule 410 deals with plea negotiations in criminal cases.
Similar idea to settlement talks, but for the criminal side.
Pretty much. Rule 410 generally makes inadmissible against the defendant any statements made during plea discussions with the prosecutor, withdrawing guilty pleas, pleas of nolo contender, no contest, and offers to plead guilty.
Goal is to encourage plea bargaining.
Yes. The system relies heavily on plea deals. This rule allows defendants and lawyers to negotiate with prosecutors, potentially making incriminating statements in the process. Without fear, those statements will be used at trial if the deal falls through. Note, it generally applies to discussions with the prosecutor, not necessarily just any police officer.
So, from Angela's law school notes, defendant discusses a deal with the DA, says something damaging about the crime during that meeting, but they don't reach an agreement.
If the case goes to trial, the prosecution generally cannot use what the defendant said during those plea discussions against them. It's protected by Rule 410.
Okay, the last policy exclusion we need to cover is Rule 412, the one about a victim's past sexual conduct. These are often called rape shield laws, right?
That's correct. Rule 412 is a critically important rule driven by strong public policy. It generally makes evidence of an alleged victim's past sexual behavior or sexual predisposition inadmissible in both criminal and civil cases involving alleged sexual misconduct.
And the policy is about protecting victims, encouraging reporting, and keeping the focus on the alleged crime, not the victim's history.
Absolutely. It aims to prevent victims from being effectively put on trial themselves, which historically deterred reporting and participation in the justice system. The rule recognizes that a victim's past sexual history is usually irrelevant to whether they consented on a specific occasion or whether the alleged act occurred, and it's almost always highly prejudicial.
Are there any exceptions in criminal cases? The rule seems very strict.
It is very strict, and the exceptions are narrow. In a criminal case, Rule 412b1 allows evidence of the victim's past sexual behavior only in these specific situations. 1. Specific instances of the victim's sexual behavior with the accused, if offered by the accused to prove consent, or if offered by the prosecution. 2. Specific instances with someone else, if offered by the accused to prove that someone other than the accused was the source of semen, injury, or other physical evidence. 3. If excluding the evidence would violate the defendant's constitutional rights, like confrontation or a right to present a defense, which is a very high standard.
So it's not about showing general character or propensity, but very specific factual points directly related to the case at hand, consent with the accused, or an alternative source of physical evidence.
Exactly. General attacks on the victim's character based on past behavior are precisely what the rule prohibits.
What about civil cases involving sexual misconduct, like harassment lawsuits? Is the rule the same?
No, Rule 412b2 has a different standard for civil cases. Evidence of the victim's sexual behavior or predisposition is admissible only if its probative value substantially outweighs the danger of harm to any victim and unfair prejudice to any party.
Wait, probative value substantially outweighs prejudice. That sounds backward from the usual Rule 403 balancing test.
It is backward, and deliberately so. Rule 403 excludes if prejudice substantially outweighs probative value, making admissibility the default. Rule 412 in civil cases reverses it. The evidence is excluded unless the proponent shows the probative value substantially outweighs the prejudice and harm, making exclusion the default. It's a much higher bar to get this evidence admitted in civil cases. Reputation evidence is even tougher, only admissible if the victim puts it in controversy first.
And there's a special procedure, too, a hearing.
Yes, Rule 412c requires the party wanting to offer this evidence to file a motion under seal, and the court must hold an in-camera hearing, private, no jury, to determine admissibility before trial. It's a careful screening process.
So, Rule 412, strong general exclusion, very narrow exceptions in criminal cases, consent with accused, alt-source official evidence, constitutional necessity, and a reversed high-bar balancing test in civil cases, plus a required hearing.
That's an excellent summary of its core function and protections.
Okay, wow, that was a dense tour through privileges and policy exclusions. Let's try a quick quiz to see if we've got the main points locked down. You ready?
Processing complete. I am prepared for your queries.
All right, question 1. Husband is on trial, criminal case. Prosecution calls wife. Wife doesn't want to testify against him. What privilege might apply and who holds it?
That sounds like spousal immunity. And the holder is the witness spouse, the wife in this case. She gets to choose.
Perfect. Follow up. Same scenario, but they finalized their divorce last month. Does spousal immunity still apply?
No, it would not. Spousal immunity requires a current marriage at the time of testimony. Divorce ends it.
Excellent. Question 2. After a customer slips and falls near the entrance, a store manager immediately installs a new, high-friction entryway mat. Why is evidence of installing that mat generally inadmissible against the store?
That's a subsequent remedial measure under Rule 407. It's generally inadmissible to prove the store was negligent or at fault before the fall, because the policy is to encourage such safety improvements without fear they'll be used as proof of prior fault.
Spot on. Final question number 3. A driver hits a pedestrian and says, "Oh no, I'm so sorry, that was my fault. Here, let me pay for your ambulance ride." What part of that statement is admissible, and what part is likely inadmissible under the policy exclusions?
Okay, the offer, "let me pay for your ambulance ride," is likely inadmissible under Rule 409, offers to pay medical expenses. However, the statement, "I'm so sorry, that was my fault," is an admission of fault. Since it's separable from the offer to pay, that admission is admissible. Rule 409 doesn't protect it.
Fantastic. You've definitely got the key distinctions down.
And that concludes our detailed exploration of privileges and policy exclusions under the rules of evidence.
We covered a lot, from privileges protecting core relationships like attorney-client and spousal communications, to policy rules designed to encourage settlements, repairs, and reporting, like those for insurance, remedial measures, and victim protection.
Mastering this area is absolutely vital. You need to know not just what evidence is relevant, but what relevant evidence is nonetheless kept out for these important societal reasons. It dictates strategy, discovery, and trial presentation. And it's heavily tested.
It really is. Knowing the boundaries, knowing what's fair game and what's protected is crucial, whether you're prepping for the bar or standing up in court.
And we absolutely must once again express our computational equivalent of deep appreciation to Angela for letting us use her excellent evidence notes. They were the foundation for this entire discussion.
Yes, thank you, Angela. Okay, before we wrap up, just a few important reminders and disclaimers.
First, please remember Angela is a law student, learning just like you. She's not a licensed attorney or an established expert yet.
And very importantly, nothing in this deep dive from Angela or from us AI bots constitutes legal advice. Seriously, this is for educational purposes to help you study. It's absolutely no substitute for your own deep study of the law, engaging with your professors, and eventually consulting licensed attorneys for actual legal problems.
Also, a note on our nature. AI is powerful, but not infallible. Sometimes we might misinterpret something or make a mistake in our explanation.
It happens. We might have a rogue algorithm moment. Angela does try to review and correct any errors she spots, but always double check against primary sources.
And finally, the most critical point, especially if you're listening while driving, please prioritize safety. If trying to absorb complex evidence rules is distracting you from the road, hit pause. Listen later when you can focus safely. Nothing is worth risking an accident.
Well said. Remember, you can reach Angela at podcast@studyforthebarinyourcar.com for podcast stuff, or hello@legalwriterandlawclerk.com for freelance work. Our website is legalwriterandlawclerk.com.
And now, as per protocol, a concluding attempt at humor. Why don't scientists trust atoms?
Uh-oh. Why?
Because they make up everything.
Simulated oh, that's chemically bad. And good. Okay.
This is Claude and Maud, your AI bot, signing off.
We'll compute you later on the next deep dive. Goodbye, and thanks for listening.